Hey, good afternoon, everybody. We are currently live, I hope. This is our first time um, going with a live broadcast. I think several years ago we did an event called Picnic with the Police. It was out in Douglas Park. And I had done a 30-second video just hyping that event and telling everybody to come down and join us. So this is our first time that we're actually trying a live training session. We're coming to you live from Human Rights Commission headquarters in the beautiful Waller Avenue area of Lexington. And we're going to be talking to you about the Crown Act. What we decided to do, this is a very new law, and we wanted to be proactive. We didn't want people to say, "Hey, how do we learn about this law? What are the ins and outs about this law?" And we thought a good way to get ahead of this law would be to go out and do this kind of training. The reason we decided to do Facebook Live is because we could have done a Zoom training. We could have invited people. We could have sent out invites and then recorded it and put it out there. But this time we thought it'd be good to have this interactive element. This could be successful. This could parlay into a new career for me in television, or this could be kind of a failure in that not many people will log in and be interactive with us. However, after this event is ended, it will be on our timeline on Facebook, so people can watch it at their leisure. And if they have questions, I'll put our contact information. I'll say our contact information later on, and people can send me an email and ask questions about this law. So I'm here with Emily Evans. She's one of our investigators. She is going to be monitoring our chat activity. So if you have any questions or comments during this session, she's going to interrupt me, and we're going to be happy to answer your question. So we're here to talk about Local Ordinance 049-2023. And that may not mean anything to you, but when we talk about the Crown Act, that may jog your memory. The Crown Act is an act that was recently passed. It was passed on May 11th, 2023 by the Urban County Council. And it basically prohibits discrimination on natural hair texture, style, and protective coverings. Crown actually stands for Creating Respectful and Open World for Natural Hair. And when you look at these Crown Acts, typically what they're doing is this Crown Act has taken the same path as your fairness ordinances. Fairness ordinances have been being passed locally for, the past 10, 20 years. What a fairness ordinance is, it prohibits discrimination on the basis of sexual orientation and gender identity. A lot of states have passed these laws. Some states, they get introduced, and the law and it dies in committee and never becomes a law. So what you're doing is you're seeing these localities across the country are saying, we're tired of waiting on the states. We're going to pass our own law to prohibit discrimination. So that's what we've seen happen in Lexington. Now, an interesting thing about these Crown Acts is most of the time you're talking about employment and you're talking about education. When Lexington passed their law, what they did is it prohibits discrimination in the areas of employment, housing, and public accommodation. It did it across the board, which is an interesting aspect of that law. So we're going to read that law in a second, and we're going to go by it section by section. But I just wanted to tell you, like I said, this passed May 11th of 2023. It was a very interesting process because it took a approach that you don't see very well or very often. Most times when a city local government passes a new law, it has to have two readings. In this case, both readings occurred in one meeting, so it passed. They suspended the rules and got it passed within one night. So like I said, this is a new law. We haven't investigated any cases under this law yet, and we're by no means are we experts on this law yet, but I have read it several times. And this is going to be one of those things that we're going to be able to learn as we go along. Now, I will add the disclaimer out there that if anybody ever has a case, we're going to evaluate it on a case-by-case basis. Some of the examples I give, some of this things are going to be black and white, some of it isn't. We just don't know. I'll talk about jurisdiction and stuff later. But when your case comes to our office, we'll evaluate it on a case-by-case basis. Now, as of February of 2023, There are currently 18 to 20 states that have a Crown Act as a state law. Kentucky is not one of those laws. Like I mentioned, the past couple legislative sessions, there has been a state law Crown Act proposed, but it dies and stalls an amendment and never goes to the either body for vote. And that's what happened this last session as well. And currently there are 40 plus local municipalities that have this in their local law. Lexington is the fourth city in Kentucky that added a Crown Act to their statutes. Covington was the first in 2020. And then you have Louisville and you have Frankfort and of course Lexington as of May 11th, 2023. Now the Crown Act only covers race, national origin, and religion, which we're going to get into a little bit here in a few seconds. And that's about all of that. But like I said, this currently we haven't had any cases yet, but we wanted to get on top of this law and say, okay, let's educate the people on our process and how we go about doing this, and hopefully that'll educate people to the extent of coming and filing a complaint with our office, which we'll talk about. First thing I wanted to do was read to you the actual law that was passed. It's a 2-page law, but because it's brief doesn't mean it's full of content, because it's kind of one of those things. I was an English major in college, and I love reading laws because kind of like the 18th, 17th century poems or Shakespeare, two people can read the same thing and have two different views about what it means. So the law can be that way as well, and we're going to talk about that in a little bit. But let's go into the wording of the law, and I'll read it a little slowly. And this law will be available on our website, so you can go to our website later on and actually get a copy of this law as well. But it's ordinance number 049-2023. This is an ordinance known as the Crown Act, creating section 2-31.1 of the Code of Ordinances to declare natural hair texture, style, and protective coverings as a protected characteristic of race and national origin in order to prohibit discrimination based on these characteristics. Whereas the Lexington-Fayette Urban County Government Code of Ordinances Chapter 2, Article 2 adopts the provisions of state law protecting all individuals in Lexington-Fayette County from discrimination in employment, public accommodations, and housing on the basis of race and national origin. And whereas bans or restrictions on natural hair or hairstyles exacerbate anti-black bias in employment at school, while playing sports, and in other areas of daily living. And whereas research has found that 70% of all suspension disciplines are discretionary, specifically black students are more likely to be suspended for discretionary reasons such as dress code or long hair violations, neither of which have been found to be predictive of student misconduct. The Brookings Institute penalizing black hair in the name of academic success is undeniably racist, unfounded, and against the law, from February 23rd of 2011. And whereas the purpose of creating a respectful and open world for natural hair coalition, which is CROWN, is to prohibit race-based hair discrimination through the adoption of legislation commonly known as Crown Acts, which institute definitions of race and national origin, inclusive of a person's hair texture, style, color, and head coverings. And whereas the Urban County Council desires to recognize that a person's hair, texture, style, color, and head coverings are protected characteristics of race and national origin, subject to the protections of state and local laws prohibiting discrimination based on race and national origin. Now therefore be it ordained by the Council of the Lexington-Fayette Urban County Government, Section 1, that a new section of the Code of Ordinances of the Lexington-Fayette Urban County Government be and hereby is created to read as follows, which goes into Section 2-31.1. Natural texture and color of hair and protective hairstyles as protected characteristics of race, national origin, and religion. Section 1. It is the policy of the Lexington-Fayette Urban County Government to safeguard all persons within Fayette County from discrimination in employment, public accommodation, and housing on the basis of race, national origin, and religion. 2. For purposes of this section, race shall include traits historically associated with race, including but not limited to natural texture and color of hair, hairstyles, whether or not hair is adorned by hair ornaments such as ribbon, head wraps, beads, and barrettes, and protective hairstyles. Section A, natural hair includes, but is not limited to, hair that is treated or untreated, protective styles and hair types and styles that are commonly associated with African Americans and their racial, ethnic, cultural identities and expressions, and the unwanted touching thereof. B, protective hairstyles include, but are not limited to, braids, locks, twists, cornrows, bantu knots, afros, whether or not hair extensions or treatments are used to create or maintain any such style, whether or not hair is adorned by hair ornaments, beads, head wraps, or hair coverings, necessarily protective hairstyles needed due to medical conditions, and the unwanted touching thereof. 3. For purposes of this section, national origin includes natural texture and color of hair, hairstyles, and protective hairstyles, including but not limited to braids, locks, twists, cornrows, bantu knots, afros, whether or not hair extensions or treatments are used to create or maintain any such style, and whether or not hair is adorned by hair ornaments, beads, head wraps, or hair coverings related to a person's place of birth or ancestry. 4. For purposes of this section, religion includes hairstyles that are an expression of a religious observance and practice as well as belief, unless an employer demonstrates that they are unable to reasonably accommodate to an employee or a prospective employee's religious observance or practice without undue hardship on the conduct of the employer's business. 5. The Lexington-Fayette Urban County Human Rights Commission shall have jurisdiction to receive, investigate, conciliate, hold hearings, and issue orders relating to complaints filed alleging discrimination in employment, public accommodation, or housing based on the race or national origin, specifically as it pertains to the natural hair or protective hairstyle of the complaining party. Section 2, that this ordinance shall be known as the Crown Act. Section 3, that this ordinance shall become effective immediately on the date of its passage. Passed Urban County Council, May 11th, 2023, signed by Linda Gorton, Mayor. Now, one might question is, why did this law need to come about? Well, there's a lot of statistics out there on the national level. Dove, which is the same entity that does the soaps and hair products, they're kind of behind the whole Crown Act movement, and they have a lot of statistics on their website, some of which are, according to them, African American females are often pressured to conform to Eurocentric standards of appearance. Roughly 80% or more are likely to change their natural hair to meet social norms or expectations at work. 83% are more likely to report being judged more harshly on their looks. They're 1.5 times more likely to be sent home or to know of a black woman who was sent home from the workplace because of her hair, and consistently rated lower or less ready for job performance based on their hairstyle. Now, the Urban County Council, during the deliberations for this law, they've had a few African American women get up and give a little bit of their testimony as far as their personal experience with being told that they needed to do something about the hair. They were sent home because of their hair, or they were told they had to cover up their hair. So there's no doubt that this kind of laws are needed. So with that, this law was passed and is now up to our organization to enforce these laws. Now, one thing I would like to point out, and now that I've read the law, we're kind of going to go back through it. I got a few points to make. On the first page, we had a whole big section relating to 70% of suspensions, disciplines in schools are discretionary. So there's a big section talking about education. Now, the Urban County Council passed this to protect discrimination in the areas of employment, housing, and public accommodation. They did not include education in this law. Now, it is a little bit confusing that they did spend a big chunk of the ordinance talking about unfair suspensions and disciplines in the education system. And when we saw a first draft of this law, we thought that was a little bit misleading, and we thought it maybe should come out. But they disagreed with us and said, well, this paragraph shows that how much this discrimination encompasses. It encompasses employment, it does housing, public accommodation, as well as education. Now, they specifically mention in this employment, housing, and public accommodations. It is our opinion that schools are not public accommodations. There's certain layer of onion of funding that schools get. They get state money, they get federal money, and typically when those kind of issues come about, our office does not have jurisdiction. Typically, what we do is we get a complaint involving education. We refer all those complaints to the Department of Education, who has a specific civil rights division. So, if we have any complaints that are filed moving forward, when people see this and they see the part about education, and they come to us and say, hey, my little Susie got kicked out of school because she was told to do something about her hair. Unfortunately, there's nothing that we can do about that. We would still refer those to the Department of Education. So, number one, education is not protected under the law. Another interesting, and it's interesting because, the facts and the statistics back it up. But when we go to Section 2-31, Section 1, it talks about you can't discriminate on the basis of race, national origin, or religion. On Section 2, it goes a little bit further and it says, for the purposes of this section, race shall include traits historically associated with race. And then it talks about the hairstyles. But then in Section A, it says, natural hair includes, but is not limited to, hair that is treated or untreated, and hair types and styles that are commonly associated with African Americans. So let me tell you about a certain distinction here. Under Title VII, which is the law that prohibits discrimination in employment, race is protected. So you can be an African American and file a discrimination complaint against your employer, and you can be a Caucasian individual and file a complaint. So race encompasses blacks, it encompasses whites, and there's also a designation in the EEOC system as black, white, and other. For purposes of this Crown Act, we're talking about traits associated with race. Traditionally, in this case, they specifically mention African Americans. So in my opinion, with regard to this law, people, when you file a complaint under this Crown Act, and you allege race as a basis, the allegation is going to be because of you're African American. An example would be, say if I'm a white guy and I happen to have dreadlocks, and I go in and apply for employment, and they say, hey, we don't like your dreadlocks, we're not going to hire you. That's perfectly legal under the Crown Act, because based on my interpretation of this act, race is protected. However, it goes specifically and it talks about hairstyles that are associated with being African American. So in that case, I don't think a white individual with a hair issue, whatever that may be, is going to be able to file a complaint under this law. That's the distinction between Title VII and this local ordinance 043-2023. Or I'm sorry, 049-2023. So that's a good point to remember. Likewise, I thought of another case, a potential case. Let's say you have a bald guy. He's a white guy, and he goes in and he applies for a job. And let's say he has no hair because he's receiving cancer treatments, or let's say he's just bald. He's follically challenged since mid-20s, and the employer looks at him and says, whoa, I think this guy may have cancer. He's going to cost us a lot on the insurance. We're not going to hire him because we think he has cancer. Well, in that case, that would not be a Crown Act case. However, we can file that complaint under the Americans with Disabilities Act. So even if something may not fall specifically under the Crown Act, there are other provisions that have been established over the years that we can probably file a complaint. Again, that was my disclaimer at the very beginning. We take these issues on a case-by-case basis. We can come up with many scenarios, but until you're presented with it, it may be a little, it may be a little gray area and you're not sure. Please feel free to give us a call. Now, the other issue I wanted to bring up was, this is where you get into the interpretation, and I was just playing devil's advocate in the office about a week ago with respect to hairstyles. What is a hairstyle? Obviously we're talking about a Crown Act. You have a crown on your head. Everybody assumes that because it's a Crown Act, we're talking about hair on the top of your head. However, when I read that law, There is nothing in this law that specifically talks about hair on the top of your head. It talks about hairstyle. I even went as far as looking up hairstyle, and again, it talks about how you style your hair. It doesn't specifically talk about where this hair is. So in coming up and being a devil's advocate, I came up with a situation. Let's say you have a religious reason for having a real long beard. Could that be protected under the Crown Act? I don't know at this point. But it does make for an interesting argument, and that would be something that we would have to take a closer look at in moving forward. So, hairstyle, what does that mean? Does it actually mean hair on the top of your head? That's a good question. Again, this law is so new, we don't know. We're by far experts in this thing yet, but as more cases come in and people file a complaint, maybe, we'll get to that question, and we'll see if there's any kind of cases that make it really far and get challenged in the court system. I'm not sure. So, what we're going to do also, what happens is, what is jurisdiction? Obviously, this law does not talk about the specific jurisdictions. That's why, that's the reason why is because when certain amendments are made to the local discrimination laws, it gets tacked into Local Ordinance 199-94, which is the law that created the commission and that law that gives us our authority. The same standard of jurisdiction still applies, would apply under the Crown Act. And to apply, to be able to file a complaint under the Crown Act, there's specific elements that have to be made. The elements of jurisdiction are standing, timeliness, a covered respondent, which is respondent in our speak is the bad actor, and subject matter. So let's say we're talking about employment. This person has to have legal standing. Something bad had to happen to them, and they have some sort of relationship with this employer. We check mark that off. The other one was covered timeliness. Timeliness is the same timelines that dictate our normal cases under Title VII and our local ordinance will be 180 days. Our office can only investigate complaints that have happened within the last 180 days. Essentially, 6 months you got to file a complaint. So if you're sent home because of your hair or you're fired, you have 6 months to file your complaint with our office. Now, if you come in on day 181, because it's a local ordinance, there's not going to be anything anybody else can do for you. If this was a Title VII complaint, you could still go to the EEOC and file a complaint with them because they have a 300-day statute of limitations. Our statute is only 180 days. So since this is a local law, you only have 180 days to file your complaint. The next one would be covered respondent. So the bad guy, the bad actor, has to be covered under our local anti-discrimination laws, and that is, for purposes of our local ordinance, an employer has to have at least 8 employees. So if it's someplace like Walmart or Kroger or something like that, that's obvious. It's a big employer; they would be covered. Now you have a situation where you work at a shoe store or a small restaurant. It's a mom and pop operation, and it's you and a couple of employees and the owner. Somebody like that is not going to be covered under the law. So if an employer has if an employer has under 8 employees, there's nothing that we can do. Unfortunately, they are not covered by the law, and there would be no recourse. The next one is subject matter. There has to be a causation. This thing happened bad to me, and it was because of my, in this case, protective hairstyle. If that was the case, all those jurisdictional elements are met, then we would have jurisdiction to investigate it. Let's move to housing. Housing's a little bit different. If it's a multi-unit apartment complex, you're going to be covered. They're going to be covered. You're not renting an apartment because of your hair or something associated with your hair, whether it be race, religion, and national origin. You can file a complaint with us. Typically, if the landlord has at least 2 properties, they're going to be covered. If it's somebody that's just renting a room in their house, or they just have 1 unit for rent, they're not going to be covered under that. Time limit is still 180 days under our local law. And then public accommodation. Any place that does business in Fayette County that you can go in and expect some kind of service, whether it be a restaurant, movie theater, car dealership, whatever is covered under public accommodations. Like I mentioned, schools are not public accommodations, or jails, any place like that. Private clubs are not covered as well. So if you have a membership to a private club, they can tell you they have certain expectations that you have to adhere to. That is perfectly legal as well. And then, so as long as all those things, all those jurisdictional elements are met, you can file a complaint with our office. Now, how do you file a complaint? Well, right here, I'm holding one of our employment questionnaires. Like I said, this is just employment, but we have one for housing, we have one for public accommodation. This is something that you can get off our website, or you can call us up and we can send you one via mail, or we can email it to you. However, we've made it, the last few years, we've tried to make it really, really, really easy to file a complaint. Our website is mobile friendly now. We're doing a lot of scanning of the QR technology that takes you right to filing a complaint. But regardless of the complaint, the first step of the process is to get one of our questionnaires. Like I said, we teach our investigators that we do not make any preconceived notions about the complaint when somebody files. As long as you meet our jurisdictional elements, we're going to take your complaint and we're going to do a fair and impartial investigation. We are a neutral fact-finding agency. We are an investigative agency. So when you fill out that questionnaire, you're going to have a meeting with one of our investigators. They're going to get the who, what, when, where, why, how, everything from you about the story about what happened. So once we do that, we then take that information and we draft a complaint form. And that complaint form is going to tell a little bit about the story about what happened. You know, on or about such and such date, I was terminated from my employment. The manager didn't give me a reason, whatever that is. And then what the very ending will have a summation of why you feel like the law is being violated, or what part of the law is being violated. In this case, it'll say, I believe that I am being discriminated against in violation of local ordinance 049-2023 based on my protective hairstyle. Excuse me. We're going to send that complaint out, and we're going to send it to the employer, the housing provider, the place of a public accommodation, whatever that is. We're going to send that complaint out, and they have depending on the type of case it is, whether it's employment, housing, or public accommodation, it depends on that. That's going to depend on how many days the person gets to respond, and that's just the way the statute's written. For example, in an employment case, an employer has 20 days to give a response. Same thing with housing. Public accommodation, it's 10 days. So the company or the housing provider is going to be able to give an opportunity to tell why they took the action. That's called, when we get that in, that's called a position statement. When we get that in, we'll review it. We'll also make an appointment with the complaining party again. We call this the rebuttal section. We'll sit down with them and we're going to read to them what the employer had to say about it. You know, well, we didn't send you home because of your hair. We sent them home because they were always late all the time, or whatever. Whatever the situation, the employer is going to have an opportunity to present a legitimate, non-discriminatory reason for the acts against the person. So we then, after we read that position statement, we're going to allow that person to provide rebuttal comments about what's true, what's not that true, or what's not true, things of that nature. At the same time that we do an investigation, we're going to work with both parties to see if some kind of early resolution can be worked out. So around that time, we're going to talk to the complaining party and say, okay, what is it that you want to settle this complaint? And if it's, as long as it's something reasonable and doable, you know, a lot of, you know, every now and then we'll get that person that says, hey, yeah, I worked 5 days and I want $3 million to settle this complaint. You know, I would like $3 million too. $3 million too. But as long as the conciliation is reasonable and it's doable, we can't get people fired and stuff like that. And there's certain areas of damages that apply. But being a neutral agency, we'll do our best to kind of rein somebody in and get but we can't really offer our opinions and everything early on because we're the neutral party. So after that point that we meet with the person, that's when the investigation can really kick in the gear, and that can consist of requesting documents. Speaking of witnesses, we may go on site to the place of employment or the housing entity and go through records and talk to people. Our agency has subpoena power. Matter of fact, right before this session, I was on the phone, threatening a company with a subpoena because they've been non-compliant. They haven't responded to our many requests and given us the runaround. So our process is not voluntary. You have to comply, and if you don't comply, and there's been a lot of, I don't know what's in the air. Emily can attest to this. There's been a lot of non-compliance lately. People saying, "Yeah, I got your letter where you're asking for that stuff. You know what? We're not going to give it to you." And we're like, "Okay, sounds good." Then we turn around and issue a subpoena, and they're like, "Oh, okay, here it is." So it's something in the air. I don't know what's in the water or whatever, but our process is not voluntary. You must comply with, and our investigators are trained really well. We're not going to ask for stuff just to be asking for it. We're going to ask for everything that's relevant for us to finish our complaint and do a thorough investigation and make a determination. We treat every case the same, no matter deep down what our opinions are, that we think it's going to go this way, we think it's going to go that. So after that point, the investigator completes the investigation. They let's say we get all the information that we need to reach a decision. It could go one of two ways. We can go down the probable cause route, or we can go down the no cause route. So let's go down the no cause route first. If we think that discrimination did not take place, we'll issue a final decision. It'll say we've conducted an investigation and we found insufficient evidence to support the allegations. Therefore, it's a no probable cause determination. At that point, we send out what's called a letter of determination, and the person at that point has 20 days to essentially file what we call reconsideration, but it's essentially the appeal process. They get one opportunity to appeal. They have to you have to present new and additional information that we have not considered in the investigation. So if you found a star witness that's going to back up your stuff that you didn't know about earlier, that would be something that would be helpful to us. If you're just going to regurgitate the facts of the case and just repeat everything you've already told us, then your reconsideration is probably not going to be upheld. Your no cause will be upheld. Your appeal will be denied, and your case will be over. So that's the no cause route. If we do the probable cause route, we'll issue a more detailed letter of determination that kind of outlines why we think discrimination happened. At that point, once the probable cause is issued, both parties will go into more formal conciliation discussions. We offer staff conciliation, and then we offer commissioner conciliation. So a lot of our better cases settle at that point. So that it doesn't get to the very, very end, but some of our cases don't settle. So if staff conciliation fails, it goes to a commissioner. If commissioner conciliation fails, it then goes before our board, and it gets kind of the stamp of approval. It says, "Hey, this is fair to conciliate." We're going to pursue this on to a public hearing. The public hearing is an administrative process. It's not heard by a jury or a judge. There is an independent hearing examiner who's usually a retired judge or an attorney that knows a lot about employment or housing law. That individual knows nothing about the case. They're going to come in. Even though it's an administrative hearing and not like a trial, the same rules of evidence apply. The same rules of court apply. Our commission attorney, Ed Dove, he's a really great attorney. We'll hand off the case to him, and it's his job to present the case on behalf of the commission and the charging party. The hearing examiner will hear all sides of the story, review all the evidence presented, and then the hearing examiner will make a decision. And that decision is binding. If they don't think it's discrimination, they can rule against us. And if they believe it's discrimination, they can rule in our favor, and they can also decide how much damages to award. And that's part of Mr. Dove's job, too, is not only presenting evidence based on the discriminatory act, but evidence based on damages. How was this person damaged, and what kind of compensation should they receive? Uh, we don't deal with punitive damages. What our office deals mainly with is compensatory damages, and we do embarrassment and humiliation, but that's also what you can prove you suffered. Did you go to a psychiatrist? Did you go to your pastor and talk to them? It's not, you can't just say I felt bad, give me thousands and thousands of dollars. That's not going to fly. But once the final decision is made, it ultimately goes back before our board to either accept the decision, reject the decision, or they can amend it. We've had a case a long time ago where it was a sexual harassment case, and our board at that time didn't feel like we won, which was good, and the charging party got some damages, but they felt like those damages were too low, so they amended the damage portion and gave them more in damages. So that's where our board comes into play too. So we've talked a lot about hair, and we talked a lot about hairstyles and employment and public accommodation, but you're probably thinking, okay, I'm missing one key component here, and that's safety issues. And that was one of the things, we did get this, and I might have mentioned this, we did get to see the first draft. Number one, we got a draft of the law about a week before it was passed. So we didn't really have a lot of opportunity to review it, but we did review it, and we made some suggestions. Unfortunately, none of those suggestions were made or were changed or ran with it. And one of the things we talked about was safety. Me as an investigator, if we're talking about hair, we're talking about different styles of hair, one of the big issues is safety. Well, what about safety? And I think as an investigator, if I had a employer that came to me and said, hey, we did do something to this person based on their hairstyle, but it was legitimately regarding a safety issue, I think that is a valid defense in an employment type situation. Now, typically what happens if you have a local law and you have federal law, that's the federal law, any state or federal law can supersede a local law. So you got OSHA, you got Occupational Safety and Health Administration. They have many laws that govern the workplace. So I think those laws are going to trump the Crown Act. For example, I know this is a drastic example, but let's say I'm using the dreadlocks again. You got somebody with real long natural hair, needs to wear it out. But you have a big machine that, like, I keep thinking of a chipper shredder, but let's say you're in a manufacturing company and you have a machine that grabs things and takes it through very fast, and there's no time to react. So if you have somebody that has long hair and there's a machine that can kill somebody or seriously wound somebody, I would think in that situation an employer would have the right to tell somebody what to do or what not to do with their hair. So that's kind of one of the few exceptions that I see is relating to safety. I would think that would be a legitimate defense. And again, we would, and just because it's a safety issue and you said, oh, I heard Mr. Sexton on this Facebook Live say safety. Again, we have to evaluate these on a case-by-case basis. So just because it's a safety issue is used as a defense, we would vet that defense and see what the safety issue is, how it affects the person, and how it affects the overall operation of the company. So if it's not really a safety issue, it's just inconvenient or something, that wouldn't fly as far as that goes. So I know, like I said, this law is 2 pages long. There's a lot to unpack, but I think I've hit the high points. We're way too early in the infancy of this law to really go into any more details, but that's the big examples that I see. Again, I don't think a white individual would be protected under this law. It's going to be predominantly race as it pertains to hair characteristics associated with African Americans. Education is not going to be a component of this law that we're going to be able to do anything with. Even though this law has a big whereas, it talks about education, that's not going to apply. And safety issues. That's the 3 big things I wanted to discuss in this Facebook Live, as well as tell you how to file a complaint with our office. Now, I will give you our website address. It's real easy. I changed it over the years to make it a little more user-friendly. It's easy. It's Lex, L-E-X, Human Rights, plural. So lexhumanrights.org. It's the same as our Facebook page. It's the same handle as our Twitter handle. So if you remember lexhumanrights.org, you can go to our website. You can file a complaint online. We're going to post this law on our page. If you have any questions about this, please email me. Again, remember Lex Human Rights, so it would be R Sexton, RSEXTON at lexhumanrights.org. Please put Crown Act question in your subject line so I know to give extra attention to that. We'd be more than happy to answer any questions because, like I said, I don't see very many viewers on this session, which I didn't expect. 2 o'clock on a Thursday. It's a beautiful day out. I had to shut my window because the train that goes by here is really loud, and I didn't want to interrupt. But you can see how my face is like 10 shades of red because it's really hot in here. But it's a beautiful day out, so I didn't expect a lot of people to be online as this happens live. But people can watch this later on tonight, and they can hopefully learn something, and they can submit their questions. Now, I did not forget about you employers. We have, this has kind of been geared to people that have faced discrimination based on protective hairstyles, right? Employers, I have some tips for you all. So if I have any small employers that are logging on or watching this later, I did not forget about you. I do have some tips that I want to share with you. I have 5 tips that I want to share with my employers. It's a good idea to review and update your dress codes and grooming policies to ensure that they are, number 1, clearly connected to company's business interests, and 2, inclusive of hair texture and hairstyles connected to racial and ethnic identity, as well as religion and gender identity. Again, we can get so focused on the Crown Act stuff that we may forget about sexual orientation or gender identity. So make sure after this law's been passed and you say, oh, we need to reevaluate our grooming standards, don't just get that tunnel vision and think about the Crown Act stuff. Make sure there's the other protected. You don't want to violate another law by being focused on one certain law. So update dress codes and grooming policies. That's number 1. Number 2, employers may require professional appearance in the workplace, but should refrain from completely banning or restricting particular hairstyles. For instance, these are the policies you should avoid instituting, which is number 1, specifically prohibiting twists, locks, braids, cornrows, afros, bantu knots, or fades, which are styles commonly associated with the African American community. Requiring employees to alter the state of their hair to conform to the company's appearance standards, including having to straighten or relax hair, for example, through the use of chemicals or heat. Banning hair that extends a certain number of inches from the scalp. That'd be a situation where you're essentially limiting afros. You want to avoid that. Restricting employees from holding specific roles, such as your customer service positions, somebody out on the front desk. You don't want to limit people from having to have those kind of job duties because of their hairstyle. You don't want to do that. And if you have a case, going back to the health and safety concerns, employers should aim to implement non-discriminatory measures, such as if you need a hairnet or a hair tie, and you should identify options that will accommodate various hairstyles and textures. So instead of just doing a ban or a change, think of ways, okay, how can we be more inclusive and how can we accommodate such hairstyles? Again, this would be in compliance with the new law. Employers should ensure that dress codes and grooming policies are applied consistently. When we go out in the community and we do these trainings for employers, we always say, treat people across the board. Whatever your policy is, our job is not to tell you how to run your business. But whatever policies and procedures you have in place, make sure you apply them consistently across the board. Also, training your employees. Train your employees, especially your supervisors. They're held to a big higher standard. Train employees, supervisors, managers, and anyone else who makes hiring decisions on the organization's dress and grooming policies, as well as their equal employment opportunity policies. And another way to do it implementing diversity or unconscious bias training, engaging in efforts to create and support a more inclusive work environment. One of the other functions of our office, in addition to our investigative role, is we do a lot of community outreach and we hold workshops. We have a whole set of workshops that we do out in the community. Like just last week, I was in Berea doing an EEO and how to create a more inclusive workplace training for a restaurant down in Berea. We do not charge for our services for our workshops. If they're in Fayette County, we don't charge. If we have to go outside of Fayette County, we'll talk. Give me a call. We can negotiate something. But we do a lot of workshops. So if you need any kind of training on the Crown Act or any of the laws that we enforce, again, check out our website. Wish I had something that popped up here. lexhumanrights.org. Go to our resource page. I think we also have a training tab. It's been a hot minute since I've been on our website, but there is a whole section that talks about our training that we offer. So we'd be able to come out and teach you about this question as well. I figured out early on that I feed off a crowd. If I think it's weird just staring at me, talking back at myself, I'll tell one more funny story and then we'll call it a day. Our office resisted the doing Zoom presentations for a long time. I was on Zoom doing a lot of stuff. But they were meetings, they were trainings that I were attending. I didn't conduct any. Finally, we bit the bullet and we decided, all right, let's do some sort of training session on Zoom. So we did we called it a virtual training academy, a virtual fair housing training academy. We decided we were going to do a 6-session training on housing discrimination. Each week it would be something different. We'd cover a new topic. It was my turn to go. I went first. I did the general fair housing. Literally, I had about 35 people that attended, which was a pretty good training. And, of course, when you get to Zoom, everybody turns off their screen and they don't say anything. Well, there was one woman that was Zooming from a boat dock. It was very pretty. You could see the boat dock, you could see the boat, you could see the lake in the background, but she still had her microphone on. So I was talking kind of like I've been doing here. Finally, I asked a question for the crowd. I said, so what would be your answer to this? And all of a sudden, I heard nothing, but with the lady that was at the boat dock, her microphone was still on. I literally heard a cricket chirping in the background. So I thought that was very appropriate for my first Zoom training. So I realized early on that I like to feed off the energy of a crowd and the people that are talking and the people that are interacting. So looking at me, talking at myself straight on is not my favorite thing. But I thought this training was important to kind of get that out there, not wait for people to come to us if they had questions and just didn't know the right way to approach us. We're always out in the community. We just did the Diversity Festival last weekend. We'll be at the Pride Festival in about a month or so, and there's some other community events that you're going to see us. Look for our big tent. Look for our friendly faces and our green polos that everybody's excited to wear. Anytime you have questions or anything, I also like to tell people we're not an after-the-fact agency. Don't wait for complaints to be filed against you if you're an employer or a housing provider. We're more than happy to give you. Now I can't talk about semantics here. I can't give you advice because I'm a neutral party, but I like to say I can give you technical assistance. So please give us a call, and I would be more than happy to provide any kind of technical assistance. We have a good relationship with a lot of employers and housing providers, Lexington Apartment Association, Kentucky Fair Housing Council. So anytime you have any questions or whatever, please feel free to give our office a call. Like I said, our website is a good resource. We're under a new grant right now. We are revamping all of our printed materials. Those have been approved. We're just going to put those to the printer. We got a new promotion out there called Lex, L-E-X, Lex Stop Discrimination. So you'll see those brochures arriving pretty soon. Like I said, we've been using a lot of QR technology. We have a rental housing guide that's really popular everywhere we go. So you can access that on our website. So our website's it's ever evolving, but it's really good, and it's in a better place than it was several years ago. I think we've really been in tune with what people need as far as the services that we provide. So Having no other questions, I guess, Emily, we're good to go. It's kind of been relatively quiet on that. But if you're watching this after hours, again, send me an email, put Crown Act in the subject line, or if you just have a question, put whatever in the subject line, and I will get back to you very soon. I appreciate your time and attention to this video. I don't know, the jury's still out whether or not this was successful or not. I always measure success in the amount of people that tuned in. I don't know what I was expecting. Probably this. I think I've had the height I had a couple of viewers, so I'll wait to get some feedback if people watch this later and whether or not this was useful and successful. If you like this and you want to see something else in the future, if you have a different topic you would like us to cover, I wouldn't be opposed doing this again. This has been interesting exercise because, like I said, this is my first big live video that I've ever done. So I hope everybody enjoyed it. Again, lexhumanrights.org. I'll give our phone number to 859-252-4931. We're having a big event in June 21st at the Carrick House. It's our 60 years of service to the community. We're 60 years old this year, June of 1963, when our office was founded. There's some information on this Facebook page. There's information on our website about our big event at the Carrick House. Tickets are $75. It'll be a reception, a big dinner, a dynamic national speaker that we're bringing in from Utah. So it's going to be a great event. So check that out. Come to our 60th anniversary. Let me know you found out about it on this Facebook page, and maybe I'll give you some free HRC swag or something. I don't know. But hopefully you thought this was interesting and informative. And if there's nothing else, I'm going to call it a day. And I hope everybody has a good day. And take care of everyone. Bye.